moment here while I go back. And thank you for joining us today for the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us this morning. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. So most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. Additionally, we also assist the Commissioner of Administration with issuing advisory opinions on these laws, and we also provide legislative assistance and training. So this PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you missed part of today's webinar, or if you want to go back and watch it again, or find one of our previous webinars, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. If you would like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer, so bear with me here a minute while I upload that file for you. Oh, I think I reshared my PowerPoint here. One moment. Katie, Casey, or Taya, could I get some assistance with sharing the PowerPoint, please?
Yeah, Ellen, you'll want to use the file transfer function under File. So
Thank
file
you.
Transfer, yep.
I am still learning WebEx. My apologies. Okay. So you should be able to see a pop-up window right now where you can select the file and download it to your own device. So today's webinar is another installment of Data Practices Potpourri, and that's where we highlight some of the questions data requesters and government entities raised this past spring, We will leave some time for Q&A at the end of this webinar, so you can feel free to send in your questions as you think of them using the Q&A panel on your screen. If you do that, please make sure to select all panelists when you send in your questions so we can be sure to see them. And you can begin sending them now, or you can wait until the end of the presentation when we begin answering questions. All right, so let's get started. So the first question we have is regarding records retention. We receive a number of questions from government entities unsure if they need to keep certain data once it is no longer in use. So here, the entity has some data on records, some TPS reports, but they no longer need them. Can they delete them? And the answer is maybe. So whether or not an entity needs to preserve and maintain certain data will depend on its records retention schedule. So if the data are listed on your retention schedule, you must keep them for the period of time listed. And official records that are past the retention period listed, or data that are not considered official records under Minnesota Statute 1517 may be deleted. The crucial step in this scenario is to locate your records retention schedule and see how long you need to maintain these TPS reports. So historically, our office used to advise on records retention issues, but we no longer have that authority. So if you have questions regarding developing or updating your retention schedule, we do suggest reaching out to the Minnesota State Archives for assistance. And there is a link to the State Archives contact page there. State Archives staff also visited the Data Practices Office virtually this past year, and we recorded their presentation and posted it on our YouTube page for reference in case you are interested. Okay, so the next question we have today is whether a government entity can charge a flat rate for copies of government data. We do quite regularly hear from requesters questioning whether an entity may impose a flat rate, for copies of a document regardless of its size. And so, yes, an entity may charge a flat rate, but there are some things to keep in mind here. So costs for copies are addressed in Minnesota Statute 1303, Subdivision 3C. And in that provision, entities may charge 25 cents a page for up to 100 pages or the actual cost for anything over 100 pages or electronic data. And there is a link on this slide to our website page on calculating, actual costs. So it is possible that some entities have some preset rates for copies of data that are actually just calculations of what the actual cost is following 1303 subdivision 3C, or that are less than what is permitted under this provision. And so if that is the case, the entity should be documenting this actual cost calculation so that if there is confusion, it can provide the requester with this breakdown. And listed here are some advisory opinions discussing this issue. So again, if the flat rate reflects these actual costs or is less than the actual costs, it would align with these discussions. And again, a link here to our page on actual costs is included as well. But one kind of more unique circumstance to note here is that there are some statutory provisions that provide for a different fee structure for government data. So examples of such provisions are listed here, such as county recorder fees, vital records, and driver and vehicle records. So if an entity's flat rate fees do not reflect the costs as outlined in 1303 subdivision 3C, they should be pointing at a specific statutory provision that permits them to charge this different rate. So if you are a government entity and you're charging flat rates for certain records, we definitely suggest documenting the cost calculation under 1303 subdivision 3C or noting any statutory authority for the fee structure just to avoid requester confusion. So we receive questions from law enforcement agencies about maltreatment and abuse investigations fairly regularly. And these can be, some of the more challenging data practices questions because they do involve multiple data subjects whose data are private. And a common question is when one parent, such as the mom in this scenario, reports the other parent for abuse. So the police investigate for criminal activity, but no charges were filed and the case is now closed. So if the dad requests access to the police file, what can he access? So section 1382, subdivision 8, classifies active or inactive data that identify a victim or alleged victim of maltreatment as private. And subdivision 1382 subdivision 9 classifies inactive investigative data for cases that do not result in charges or where the statute of limitations has run as private. So generally, inactive investigative data under 1382 subdivision 7 are public, but here, because of subdivision 8 and subdivision 9, investigative data that identified the victim are private, and data related to the abuse or neglect are also private, because in this scenario, there was no charge or court proceeding. So in our scenario here, no charges were filed, so subdivisions 8 and 9 come into play. So identifying data about the child, dad, and mom are private, and data identifying a reporter of maltreatment would be confidential. And additionally, parents have the right to access information about their minor children unless there is a court order limiting their rights, like a termination of parental rights. And that is not in existence here, so therefore dad can have access to information about him and his child, and data about others would need to be redacted. So as you can probably see, this can get complex. So given the complexity, of these situations, we do suggest consulting with your legal counsel regarding redactions, since determinations on what is appropriate to provide the requester while protecting other identities can definitely be difficult. And one final note here is that 13821 limits access to videotapes where the child victim is alleging, explaining, denying, or describing abuse. So if such a recording is present in this case, dad would need a court order to obtain that videotape. So another law enforcement question here. Can a law enforcement agency release investigative data to a victim? So if the victim requests data from law enforcement are only authorized to provide public data or private data about the subject to the victim. If the investigation is active, that means that much of the data will not be available to the victim from law enforcement. However, 1382 subdivision 13 does permit the prosecuting authority to release investigative data from law enforcement, providing that the prosecutor does not believe the release of this data will interfere with the investigation or that the release from the victim is prompted by a desire on the part of the requester to engage in unlawful activities. So this is a decision for the prosecutor to make. So if law enforcement receives a request from the victim, they should refer the victim to make a written request to the prosecutor. And then it is helpful for law enforcement to, have a conversation, have a dialogue with the prosecuting authority in these situations, since the prosecutor will need to understand the status of the investigation and if the release of the data would interfere with it. And just a note here that 1382 subdivision 13 applies to law enforcement data on adults, but there is a similar provision in existence for juvenile records in 260B 171. So regardless of the offender, reaching out to the prosecuting authority to discuss this data request and provide information on the investigation will definitely be helpful as the prosecutor determines whether the release of the data is appropriate. Okay, so a frequent question we receive is what is the classification of a data request? So some government entities will receive data requests to obtain other data requests they have, and they are curious whether such data may be released. So the quick answer here is that requests for public data will themselves be public data, and that requests for private data will likely be private. So there is not a classification for data requests in the Data Practices Act. So the public presumption will apply to data requests, and most requests will also be public data. And this includes contact information, provided by the requester and their name, since there is nothing that classifies it as not public data. If the request is from a data subject and the request is for private data, that data request itself will also be private. And there can be a few reasons why. So for example, here, if a public employee asks for a copy of their performance evaluation, that would be private personnel data under 1343. Because here the data request was created because the data subject is an employee of the entity. And as you may know, personnel data is presumptively private unless classified public, and data requests from an employee are not one of the public data elements in 1343. So another different example, if a person receiving social services asks for a copy of their file, that would be private welfare data, under 1346, as just, that request itself would reveal that the individual is receiving welfare services or, could provide other private information classified under 1346. So for requests for private data, other provisions will apply, and looking at that underlying data will drive sort of the classification of that data request. Okay, let's do one last question here focused on the open meeting law. So we have a public body here where its members would all like to attend the same social event. So do they need to notice a special meeting in order to attend the same event? And so this gets at what constitutes a meeting, under the open meeting law. Chance or social gatherings where members uh, do not discuss, decide, or receive information related to the official business are not considered meetings under the open meeting law. And so advisory opinion 18003 discusses these chance meetings, and the Minnesota Supreme Court opinion St. Cloud Newspapers versus District 742 also notes that these social gatherings would not fall under the open meeting law. But remember, what constitutes a meeting under the open meeting law is a gathering of a quorum of members where they discuss, decide, or receive information on issues related to the official business of that body. And this definition is from the Minnesota Supreme Court decision in Moberg versus Independent School District 281. And Moberg also cites that St. Cloud case from the previous slide, noting that chance or social gatherings would not constitute a meeting, but a social event where members do discuss, decide, or receive information as a group on these issues related to their official business would be considered a meeting under Moberg and should be noticed properly. So saying it is a private social gathering does not necessarily absolve the entity of notification requirements under the open meeting law if the gathering would otherwise, meet this definition. So because of this, if there is a quorum of public body members and they're attending, the same social event, they should really take care to avoid discussing any such issues or topics. And remember that courts have repeatedly said that the open meeting law will be construed liberally, in favor of the public. So if a quorum of members is attending a social event and thinks there may be a possibility of such discussions or receiving information, or even that it may appear that way, they should consider noticing the event as a special meeting to support these transparency goals. All right, so those are our questions today. And now we are happy to discuss any questions you may have. Please feel free to submit questions using the Q&A panel. Remember to send them to all panelists so we can be sure to see and respond to them. I do have a few reminders on this slide. This slide deck is available on our website, and you will be able to access the recording on our YouTube page in the next day or two. And in just a moment, I'm also going to put up the evaluation in the polling panel. And if you could please fill that out and let us know how we did and what other topics you'd like to see in the future, that would be wonderful. We want to make sure these webinars are helpful for you, so any feedback you have is greatly appreciated. So I'm going to open that poll while we get started answering your questions. So you should see that poll, and if it is quiet for a moment, your WebEx is working just fine. It might be a little silent while we navigate the questions and get our responses going. So thanks, and one moment here, we'll begin answering your questions.
Here's a question. So with data practices requests seeking private data, are you advising that the request is public unless there's a specific provision that makes it private, such as 1343? The thing with private requests for private data, if the person is a data subject asking for private data about themselves, the data that they're asking for could be inherently identified by the request itself. And so 1343 with employees, an employee making a data request, the fact that that employee made a data request is private under 1343 because it's not one of the subdivision 2 elements. But for something like protected identities and law enforcement data, or 1346 social services data, the data request itself isn't classified. It's that the request could inherently identify that individual. So, say somebody has a protected identity and wants to access their law enforcement data that's private. The fact that they made that data request would identify them, and they'd have that protected identity. So you would still rely on some sort of classification. It will just be driven by what the underlying data is, and if the request would identify something private about that person.
Okay, so we have a question here. If someone submits a request for data, but we redact some of the info, is this considered a private request or a public request that could be requested by another person? I think the answer to this question is that it depends. If, even with the redactions, if you can still identify someone who's the subject of private data, then I think that request or kind of the information related to that request would still be private. But let's say the redactions really clearly remove all identifying information from about an individual or about a particular person. And so no longer it's no longer related to a particular individual or a particular data subject. Then at that point, the data may just be public because it's not related to a particular person, and it's been de-identified to the point that it's no longer about a data subject. I think at that point it might just be generally public. And so I think it really depends on the case by case basis. But if you are thinking about a particular situation or a particular issue, certainly feel free to reach out to us, and we're happy to talk to you through that particular situation.
Another question, if a constituent emails a government employee and that email is part of a public data request, should the citizen's email be redacted and responsive to data that is released? So emails themselves don't have a classification. There is not a general classification for emails or just, members of the public, their email addresses. And so the content of the email that's responsive to the request will drive whether there's any classification that would require redaction. As far as the citizen's email address, when any member of the public emails a government entity, there's not a general classification for the email address. There would be limited classifications for certain contact information when signing up for some sort of notification list, such as GovDelivery, or if their contact information is part of some private information that the entity is maintaining about that person. Say, again, it's identifying information on a protected identity, or they're obtaining some sort of services that have a classification of the government entity. But the email itself will be driven by the content, and the email address would likely be presumptively public unless there's some other classification that would make the requester or constituent's email not public.
All right, we just had a question about neighbor disputes, and it asked, can you run through what is considered real property? So I'm assuming we're talking about section 13.44, which is property data. In particular, subdivision 1 classifies some data about the identities of individuals who complain about violations of state laws or local ordinances concerning the use of real property. So in general, the real property at issue there is going to be land or permanent structures on land. So to the extent that there are local ordinances or state laws about how someone is using their land or their permanent structures on their land, and someone complains, the complainant's identity is confidential under section 13.44.
We did get some feedback that folks were not able to access the PowerPoint that I shared earlier. So I'm going to try right now one more time to see if we can successfully get that to you all. And if not, it is already posted on our website on the same page where you registered. But let's try one more time for good measure here and see if we are able to get that over to you all. All right, are you able to see the pop-up and download?
Yes.
Yay. Okay, well, hopefully that works for you all. And if that file does not work, you can visit our website where you signed up for the webinar, and there is a link right there right now that will get you access to that PowerPoint as well. Looks like there are some folks who can't see the pop-up, so I'm just going to drop the website in response to them. I don't know if it's a WebEx issue or what's going on here, but the website will be able to get you access as well. So we will make sure you can get a copy.
Okay, we still have a couple of minutes, and so feel free to keep throwing some questions in the chat. We can answer a few more as we're just kind of looking up some background information for a couple of different answers here too. So just feel free to keep sending in those questions to all panelists.
We have another question. It says, sorry, back to neighbor disputes. Noise complaints would not be considered real property then. We have an advisory opinion that might be helpful on this. It's 00-036. So it's from 2000 and it's regarding the city of Minnetonka. And in that opinion, the commissioner addressed whether complaints regarding the use of an individual's property, that children were yelling around a swimming pool in the backyard, would be treated as confidential under 13.44. So that's the property complaint section. The commissioner held that the city had properly responded to the requester's data request for access, and that the identity of the people who made a complaint about the noise at the children's home regarding the use of the pool would be confidential pursuant to 13.44. So 13.44 does say the identities of individuals who register complaints with government concerning, violation of state law or local ordinance concerning use of real property. So in that instance, the noise was related to the use of the real property, and that opinion might be informative when determining whether something rises to the level of a property complaint.
All right, thanks everyone. We are just about at time. If we were not able to get to your questions, we will follow up directly with you to ensure we can get you some helpful information. Again, we hope you were able to respond to the poll and give us some good feedback. If not, it is still up, it looks like, and we appreciate your feedback. Otherwise, we hope you have a wonderful day, stay cool, and we will see you next time.